May 26, 2022, 12:33 in the morning AM. Article 225 of the Labor Code says that powers of the Commission shall have the power and authority to promulgate rules and regulations governing the hearing and disposition of cases before it and its regional branches, as well as those pertaining to its internal functions, and such rules and regulations as may be necessary to carry out the purposes of this code. B. To administer oaths, summon the parties to a controversy, issue subpoenas requiring the attendance and testimony of witnesses, or the production of such books, papers, contracts, records, statement of accounts, agreements, and others as may be material to a just determination of the matter under investigation, and to testify in any investigation or hearing conducted in pursuance of this code. C. To conduct investigation for the determination of a question, matter, or controversy within its jurisdiction. Proceed to hear and determine the disputes in the absence of any party thereto, who has been summoned or served with notice to appear, conduct its proceedings or any part thereof in public or in private, adjourn its hearings to any time and place after technical matters or accounts to an expert, and to accept his report as evidence after hearing the parties upon due notice, direct parties to be joined in or excluded from the proceedings, correct, amend, or waive any error, defect, or irregularity, whether in substance or in form. Give all such directions that may deem necessary or expedient in the determination of the dispute before it, and dismiss any matter or refrain from further hearing or from determining the dispute or part thereof, where it is trivial, or where further proceedings by the Commission are not necessary or desirable. And D. To hold any person in contempt directly or indirectly, and impose appropriate penalties therefore in accordance with law. A person guilty of misbehavior in the presence of or so near the chairman or any member of the Commission or any labor arbiter as to obstruct, interrupt the proceedings before the same, including disrespect towards said officials, offensive personalities towards others, or refusal to be sworn, or to answer as a witness, or to subscribe as an affidavit or deposition when lawfully required to do so, may be summarily adjudged in direct contempt by said officials and punished by a fine not exceeding 500 pesos, or imprisonment not exceeding 5 days, or both, if it be the Commission or a member thereof, or by a fine not exceeding the 100 pesos, or imprisonment not exceeding 1 day, or both, if it be a labor arbiter. The person adjudged in direct contempt by a labor arbiter may appeal to the Commission, and the execution of the judgment shall be suspended pending the resolution of the appeal upon the filing by such person of a bond on condition that he will abide by and perform the judgment of the Commission should the appeal be decided against him. Judgment of the Commission on direct contempt is immediately executory and unappealable. Indirect contempt shall be dealt with by the Commission or labor arbiter in the manner prescribed under Rule 71 of the revised Rules of Court, and to enjoin or restrain any actual or threatened commission of any or all prohibited or unlawful acts, or to require the performance of a particular act in any labor dispute which, if not restrained or performed forthwith, may cause grave or irreparable damage to any party or render ineffectual any decision in favor of such party, provided that no temporary or permanent injunction in any such case involving or growing out of a labor dispute as defined in this code shall be issued except after hearing the testimony of witnesses with opportunity for a cross-examination in support of the allegations of a complaint under oath, and testimony in opposition thereto, if offered, and only after a finding of fact by the Commission to the effect: first, that prohibited or unlawful acts have been threatened and will be committed and will be continued unless restrained, but no injunction or temporary restraining order shall be issued on account of any threat, prohibited or unlawful act except against the person or persons, associated or organization making threat or committing the prohibited or unlawful act, or actually authorizing or ratifying the same after actual damage thereof. That substantial and irreparable injury to complainant's property will follow. That as to each item of relief to be granted, greater injury will be inflicted upon complainant by the denial of relief than will be inflicted upon defendants by the granting of relief. That complainant has no adequate remedy at law, and that the public officers charged with the duty to protect the complainant's property are unable or unwilling to furnish adequate protection. Such hearing shall be held after due and personal notice thereof has been served in such manner as the Commission shall direct to all known persons against whom relief is sought, and also to the Chief Executive and the other public officials of the province or city within which the unlawful acts have been threatened or committed, charged with the duty to protect complainant's property, provided however that if a complainant shall also allege that unless a temporary restraining order shall be issued without notice, a substantial and irreparable injury to complainant's property will be unavoidable, such a temporary restraining order may be issued upon testimony under oath, sufficient if sustained to justify the Commission in issuing a temporary injunction upon hearing after notice. Such a temporary restraining order shall be effective for no longer than 20 days, and shall become void at the expiration of said 20 days. No such temporary restraining order or temporary injunction shall be issued except on condition that complainant shall first file an undertaking with adequate security in an amount to be fixed by the Commission sufficient to recompense those enjoined for any loss, expense, or damage caused by the improvident or erroneous issuance of such order or injunction, including all reasonable costs, together with a reasonable attorney's fee and expense of defense against the order or against the granting of any injunctive relief sought in the same proceeding and subsequently denied by the Commission. The undertaking herein mentioned shall be understood to constitute an agreement entered into by the complainant and the surety upon which an order may be referred in the same suit or proceeding against said complainant, and surety upon a hearing to assess damages of which hearing complainant and surety shall have reasonable notice to said complainant and surety submitting themselves to the jurisdiction of the Commission for that purpose. But nothing herein contained shall deprive any party having a claim or cause of action under or upon such undertaking from electing to pursue his ordinary remedy by suit at law or in equity, provided further that the reception of evidence for the application of a writ of injunction may be delegated by the Commission to any of its labor arbiters who shall conduct such hearings in such places as he may determine to be accessible to the parties and their witnesses, and shall submit thereafter his recommendation to the Commission. Order of topical presentation. The major topics discussed in this section are as follows: powers of the Commission, rulemaking power, power to administer oath, power to issue compulsory proceedings, power to conduct its own proceeding, contempt power, injunction power, power to grant extraordinary remedies. Notes and comments. Introduction. Order of topical presentation. The major topics discussed in this section are as follows: powers of the Commission, rulemaking power. 3. Power to administer oath. 4. Power to issue compulsory processes. 5. 5th. Power to conduct its own proceedings. 6. Contempt power. 7. Injunction power. 8. Power to grant extraordinary remedies. Powers granted under Article 225. The powers vested upon the NLRC under Article 225 are as follows. Rulemaking power, power to administer oaths, power to summon parties to a controversy, power to issue subpoenas, duces tecum, and ad testificandum, power to investigate a question, matter, or controversy within its jurisdiction, power to conduct its own proceedings, and for this purpose to conduct investigation for the determination of the merits of a question, matter, or controversy within its jurisdiction, proceed to hear and determine the disputes presented before it, even in the absence of any party thereto who has been summoned or served with notice to appear, conduct its proceedings or any part thereof in public or in private, adjourn its hearings to any time and place, refer technical matters or accounts to an expert, and to accept his report as evidence after hearing of the parties upon due notice, direct parties to be joined in or excluded from the proceedings, correct, amend, or waive any error, defect, or irregularity, whether in substance or in form, give all such directions as it may deem necessary or expedient in the determination of dispute before it, and dismiss any matter or refrain from further hearing or from determining the dispute or part thereof, where it is trivial or where further proceedings by the Commission are not necessary or desirable. Power to hold any person in direct or indirect contempt and impose appropriate penalties therefore or in accordance with law, and power to issue temporary restraining order and prohibitory or mandatory injunction. Additional powers. In addition to the above enumerated powers under Article 125, the Commission has also been granted the following powers. Power to grant extraordinary remedies per 2011 NLRC Rules of Procedure. 2011 NLRC Rules of Procedure has introduced a new legal concept in the nature of extraordinary remedies, embodied in its Rule number 12. Thus, the NLRC has now the power to grant extraordinary remedies in the situations contemplated thereunder. Power to conduct ocular inspection per Article 226. Moreover, under Article 226, the chairman of the Commission or any of its commissioners or their duly authorized representatives have the power to conduct ocular inspections at any time during working hours on any establishment, building, ship or vessel, place or premises, including any work material, implement, machinery, appliance, or any object therein, and ask any employee, laborer, or any person, as the case may be, for any information or data concerning any matter or question relative to the object of the investigation. Power to conciliate and mediate per Article 227 and 2011 NLRC Rules of Procedure and RA number 10396. Under Article 227, the Commission is granted the power to conciliate and mediate and exert all efforts towards the amicable settlement of a labor dispute in the exercise of its original jurisdiction. The 2011 NLRC Rules of Procedure, however, have expanded this power, hence the Commission may discharge such power not only in the exercise of its exclusive and original jurisdiction but also in its appellate jurisdiction. Moreover, it must be emphasized that the settlement of cases on appeal to be valid and binding between the parties should be approved by the Commission. Additionally, the same power is granted to the Commission in accordance with RA number 10396, which mandates the conduct of mandatory conciliation mediation as a voluntary mode of dispute settlement for all labor cases. It revived the long repealed Article 228 of the Labor Code. Number 2. Rulemaking power. Number 1. Power to promulgate its own rules. The Commission is possessed of the power to promulgate number 1. Rules and regulations governing the hearing and disposition of cases before it and its regional branches. The rules and regulations governing its internal functions, and third, rules and regulations as may be necessary to carry out the purposes of the Labor Code. Number 2. Rules promulgated by NLRC pursuant to Article 225 excuse. The NLRC has promulgated the following latest rules. The 2011 NLRC Rules of Procedure as amended by several resolutions. 2012 NLRC Sheriff's Manual on the Execution of Judgment, which forms part the 2011 NLRC Rules of Procedure. Constitutional basis of rulemaking power. The 1987 Constitution states that rules 1987 Constitution states that rules of procedure of special courts and quasi-judicial bodies shall remain effective unless disapproved by the Supreme Court. Consequently, the 2011 NLRC Rules of Procedure and the Manual, unless disapproved by the Supreme Court, cannot be said to encroach on the power of the Supreme Court to formulate rules of procedure. Liberal construction. The 2011 NLRC Rules of Procedure should be liberally construed to carry out the objectives of the Constitution, the Labor Code, and other relevant legislations, and to assist the parties in obtaining just, expeditious, and inexpensive resolution and settlement of labor disputes. In the same vein, the manual should be construed in a manner that shall attain a just, expeditious, and inexpensive execution of the judgment as defined herein. Suppletory application of rules of court and prevailing jurisprudence. In the absence of any applicable provision in the 2011 NLRC Rules of Procedure and the Manual in order to effectuate the objectives of the Labor Code, the pertinent provisions of the revised Rules of Court of the Philippines, and prevailing jurisprudence may, in the interest of expeditious dispensation of labor justice, and whenever practicable and convenient, be applied by analogy or in a suppletory manner after in effect. Number 6. Rules of force and effect of law. It is an elementary rule in administrative law that administrative regulations and policies enacted by administrative bodies such as the 2011 NLRC Rules of Procedure and the Sheriff's Manual 2012 to interpret the law which they are entrusted to enforce. So the force and effect of law are entitled to great respect. Laws must not conflict with law. It's also a basic legal tenet that the rules and regulations so issued must not be in secretary must not be in conflict with or in contrary to the provisions of the Labor Code and other laws. The Dole Secretary, for instance, has no legal power to amend or alter in any material sense whatever the law itself unequivocally specifies or fixes. Power to administer oath. Administration of oath in cases pending before the Commission. The power to administer oath is expressly granted to the Commission or under paragraph B of Article 225 to 18 of the Labor Code. Person who may exercise power to administer oath: the chairman, members of the Commission, the executive clerk, the deputy executive clerks, the executive labor arbiters, the labor arbiters, and other persons designated or commissioned by the chairman of the Commission shall have the power to administer oath on all matters or proceedings related to the performance of their duties. Number 4. Power to issue compulsory processes. Compulsory processes. The Commission is vested under paragraph B of Article 225 with the power to summon parties to a controversy and issue subpoenas ad testificandum and ducis tecum. Subpoenas ad testificandum and ducis tecum distinguished. Within the context of Article 225, subpoena ad testificandum requires the attendance and testimony of witnesses in any investigation or hearing conducted in pursuance of the Labor Code, while subpoena ducis tecum requires the production of such books, papers, contracts, records, statements of accounts, agreements, and others as may be material to a just determination of the matter under investigation. Subpoena ad testificandum requires the attendance and testimony of witnesses in any investigation or hearing conducted in pursuance of the labor code. The subpoena duces tecum requires the production of such books, papers, contracts, records, statements of accounts, agreements, and others as may be material to adjust determination of the matter under investigation. Subpoena ad testificandum requires the attendance and testimony subpoena ad testificandum duces tecum. The attendance and testimony is being conducted in pursuance of the labor code. Subpoena duces tecum, action of such others as may be directed as determination of the matter under investigation. Number 5. Power to conduct its own proceedings. Power to conduct its proceedings. Under paragraph of Article 225, the Commission is granted the power to do and perform any of the following: to conduct investigation for the determination of the merits of a question, matter, or controversy within its jurisdiction, to proceed to hear and determine the disputes presented before it, even in the absence of any party thereto who has been summoned or served with notice to appear. Number 3. To conduct its proceedings or any part thereof in public or in private. 4th, to adjourn its hearings to any time and place. 5th, to refer technical matters or accounts to an expert and to accept this report as evidence after hearing of the parties upon due notice. And 6th, to direct parties to be joined in or excluded from the proceedings. Duces tecum requires the production of such books, papers, contracts, records, statements, accounts, agreements, and others as may be material to adjust determination of the matter under investigation. The attendance and testimony of witness in any investigation or hearing. Ad testificandum, testifying, to testify. Duces tecum. That requires the attendance of the testimony. Under paragraph C of Article 225, the Commission is granted the power to do and perform any of the following. Number 1. To conduct investigation for the determination of the merits of a question, matter, or controversy within its jurisdiction. Number 2. To proceed to hear and determine the disputes presented before it, even in the absence of any party thereto who has been summoned or served with notice to appear. Number 3. To conduct its proceedings or any part thereof in public or in private. Number 4. To adjourn its hearings to any time and place. To refer 5th, technical matters or accounts to an expert and to accept his report as evidence after hearing of the parties upon due notice. 6. To direct parties to be joined in or excluded from the proceedings. 7. To correct, amend, or waive any error, defect, or irregularity, whether in substance or in form. 8. To give all such directions as it may deem necessary or expedient in the determination of the dispute before it. 9. To dismiss any matter or refrain from further hearing or from determining the dispute or party thereof, where it is trivial or where further proceedings by the Commission are not necessary or desirable. Exception. The Commission, however, is not empowered to hear or assume jurisdiction over issues involved in a case where a compromise settlement has already been voluntarily agreed upon by the parties with the assistance of the Bureau of Labor Relations or the Regional Office of the Department of Labor and Employment. Such compromise settlement is deemed final and binding upon the parties, but in case the said compromise agreement is not complied with by the parties, or if there is prima facie evidence that the settlement was obtained through fraud, misrepresentation, or coercion, then the Commission may assume jurisdiction over the issues previously made subject of the compromise settlement. Number 3. Power to correct, amend, or waive substantive or formal error, defect, or irregularity. One of the extraordinary powers granted to the Commission is its power to correct, amend, or waive any error, defect, or irregularity in its rules and proceedings, regardless of whether it is substantive or formal in nature. In many instances, the Supreme Court has upheld the exercise of the Commission of this power. On this basis, the rules of the NLRC have often been relaxed in connection with the exercise of its appellate jurisdiction. For example, the Commission has relaxed in many cases the rule that otherwise is strictly observed 10 calendar day reglementary period within which to appeal the decisions of the labor arbiter, or the rule on the late filing of a motion for reconsideration or the filing of appeal bond. Contempt power. Contempt defined. Contempt is defined as a disobedience to the court by setting up an opposition to its authority, justice, and dignity. It signifies not only a willful disregard or disobedience of the court's orders, but such conduct that tends to bring the authority of the court and the administration of law into disrepute, or in some manner to impede the due administration of justice. It is a defiance of the authority, justice, or dignity of the court which tends to bring the authority and administration of the law into disrespect, or to interfere with or prejudice party litigants and their witnesses during litigation. The power to punish for contempt is inherent in all courts and is essential to the preservation of order in judicial proceedings and to the enforcement of judgments, orders, and mandates of the court, and consequently to the due administration of justice. However, such power should be exercised on the preservative, not on the vindictive principle. Only occasionally should the court invoke its inherent power in order to retain that respect without which administration of justice will falter or fail. Only in cases of clear and contumacious refusal to obey should the power be exercised. Such power, being drastic and extraordinary in its nature, should not be resorted to unless necessary in the interest of justice. Direct contempt. The chairman or any of commissioner or labor arbiter may summarily adjudge guilty of direct contempt any person committing any act of misbehavior in the presence of or so near the chairman or any commissioner or labor arbiter as to obstruct or interrupt the proceedings before the same, including disrespect towards said officials, offensive acts towards others, or refusal to be sworn or to answer as a witness, or to subscribe to an affidavit or deposition when lawfully required to do so. If the offense is committed against the Commission or in any member thereof, the same shall be punished by a fine not exceeding 500 pesos or imprisonment not exceeding 5 days, or both. And if the offense is committed against any labor arbiter, the same shall be punished by a fine not exceeding 100 pesos or imprisonment not exceeding 1 day, or both. Any person adjudged guilty of direct contempt by a labor arbiter may, within a period of 5 calendar days from notice of the judgment, appeal the same to the commission, and execution of said judgment shall be suspended pending resolution of the appeal upon the filing by said person of a bond on condition that he will abide by and perform the judgment should the appeal be decided against him or her. A judgment of the commission on direct contempt shall be immediately executory and inappealable. Number 3. Indirect contempt. Disobedience or resistance to a lawful writ, process, order, judgment, or command of a court or injunction granted by a court of judge constitutes indirect contempt, punishable under Rule 71 of the Rules of Court. Grounds: the commission or any labor arbiter, pursuant to Article 2025, may cite any person for indirect contempt and impose the appropriate penalty under any of the following grounds: misbehavior of any officer or employee in the performance of his or her official duties or in his or her official transaction, disobedience of or resistance to a lawful writ, order, or decision, any abuse or any unlawful interference with the processes or proceedings not constituting direct contempt, any improper conduct tending directly or indirectly to impede, obstruct, or degrade the administration of justice, assuming to be an attorney or a representative of a party without authority, failure to obey a subpoena duly served, or other grounds analogous to the foregoing, where charge may be filed. Where the charge for the indirect contempt has been committed against the commission or against an officer appointed by it, the charge may be filed with the commission. Where such contempt has been committed against the labor arbiter, the charge may be filed with the regional arbitration branch, subject to appeal to the commission. How proceedings commenced. Proceedings for indirect contempt may be initiated motu proprio by the commission or any labor arbiter by an order or any other formal charge requiring the respondent to show cause why he or she should not be punished for contempt. In all other cases, a charge for indirect contempt shall be commenced by a verified petition with supporting particulars and certified true copies of documents of papers involved therein, and upon full compliance with the requirements for filing initiatory pleadings in the commission. If the contempt charge arose out of or is related to a principal action pending in the commission or regional arbitration branch, the petition for contempt shall allege that fact, that said petition shall be consolidated, heard, and decided separately unless the commission or labor arbiter in her discretion orders the consolidation of the contempt charge and the principal action for joint hearing and decision. Hearing. Upon the date set for hearing, the commission or labor arbiter shall proceed to investigate the charge and consider such comment, answer, defense, or testimony as the respondent may make or offer. Failure to attend the scheduled hearing and to give a satisfactory explanation in writing to the commission or labor arbiter will result in the waiver of the respondent to be present during the hearing. Punishment for direct and indirect contempt. If the respondent is adjudged guilty of indirect contempt committed against the commission or any member thereof, he or she may be punished by a fine of 1,000 pesos per day for every act of indirect contempt, and if the offense is committed against any labor arbiter, the same may be punished by a fine of 500 pesos per day for every act of indirect contempt. Each day of defiance of or disobedience to or non-enforcement of a final order, resolution, decision, ruling, injunction, or processes shall constitute an indirect contempt of the commission. If the contempt consists of the violation of an injunction or omission to do an act which is within the power of the respondent to perform, The respondent shall in addition be made liable for damages as a consequence thereof. The damages shall be measured by the extent of the loss or injury sustained by the aggrieved party by reason of the acts or omissions of which the contempt is being prosecuted, and the costs of the proceedings, including payment of interest or damages. A writ of execution will be issued to enforce a decision imposing such fine and or consequent damages as punishment for indirect contempt. In Industrial and Transport Equipment INC versus NLRC, the Supreme Court upheld the judgment of the labor arbiter, finding the employer guilty of indirect contempt, with a fine of 100 pesos for its refusal to reinstate the dismissed employee. Thus, the NLRC or the labor arbiter have jurisdiction to rule on indirect contempt. The answer to this question is crucial in the light of the qualification made by the Supreme Court in Land Bank of the Philippines versus Aristana Sr. In this case, it was ruled that under Section 12, Rule 71 of the 1997 Rules of Civil Procedure, quasi-judicial agencies that have the power to cite persons for indirect contempt can only do so by initiating it in the proper regional trial court. It is not within their jurisdiction and competence to decide the indirect contempt cases. These matters are within the province of the RTCs. Consequently, if the indirect contempt charge is filed not with the RTC, but with the quasi-judicial body, and it was the quasi-judicial body that decided the offender with indirect contempt, the said contempt citation is invalid. Based on this quoted provision, however, it was clarified in the 2012 case of Robosa versus NLRC Chemotechnicae Manufacturing INC that Rule 71 of the Rules of Court does not require the labor arbiter or the NLRC to initiate indirect contempt proceedings before the trial court. This mode is to be observed only and there is no law granting them contempt powers. Since Article 225 expressly grants both direct and indirect contempt power to the labor arbiter and the NLRC, the requirement in Land Bank does not apply. Nature of power. Generally, injunction is a preservative remedy for the protection of one's substantive rights or interests. It is not a cause of action in itself but merely a provisional remedy, an adjunct to a main suit. It is resorted to only when there is a pressing necessity to avoid injurious consequences which cannot be remedied under any standard of compensation. The application of the injunctive writ rests upon the existence of an emergency or of a special reason before the main case may be regularly heard. The essential conditions for granting such temporary injunctive relief are the complaint's alleges facts which appear to be sufficient to constitute a proper basis for injunction, and that on the entire showing from contending parties the injunction is reasonably necessary to protect the legal rights of the plaintiff pending the litigation. Injunction is also a special equitable relief granted only in cases where there is no plain, adequate, and complete remedy at law. As a matter of labor policy, the issuance of injunction or restraining order is generally not favored. By express provision of Article 266 of the Labor Code, no temporary or permanent injunction or restraining order in any case involving or growing out of a labor dispute shall be issued by any court or other entity except as otherwise provided in Articles 225 and 279 of the Labor Code. Notably, Article 278 has been added by the Labor Code's implementing rules. Thus, injunctions or restraining orders may not be issued perfunctorily and unthinkingly under the law and established jurisprudence. Petitions for the issuance of injunction or restraining order are required to be handled or resolved with extreme care and caution. All efforts to conciliate or settle amicable issues in the main dispute and those involved in petitions for injunction should be exhausted. Injunctions and restraining orders therefore may be issued only in case of extreme necessity based on legal grounds clearly established after due consultations or hearings, and when all efforts excuse, and all efforts at conciliation are exhausted. Two, resistance of labor dispute is necessary. The power of the Commission to enjoin or restrain prohibited or unlawful acts prescribed in Article 225 may be exercised only over a labor dispute. It is an essential requirement that there must first be a labor dispute between the contending parties. If the rights and obligations of the parties under certain contracts are not at issue in a labor case, the same may be enforced in a civil action in the regular courts, not in the NLRC. Irreparable injury. An injury is considered irreparable if it is of such constant and frequent recurrence that no fair and reasonable redress can be had therefore in a court of law, or where there is no standard by which its amount can be measured with reasonable accuracy. That is, it is not susceptible of mathematical computation. It is irreparable when it cannot be adequately compensated in damages due to the nature of the injury itself, or the nature of the right or property injured, or when there exists no certain pecuniary standard for the measurement of damages. Facts that need to be proved. Hearing to establish facts as required by law and rules. Under Article 225 of the Labor Code and the 2011 NLRC Rules of Procedure, a preliminary or permanent injunction may be granted by the Commission only after hearing the testimony of witnesses and with opportunity for cross-examination in support of the allegations of the complaint or petition made under oath and testimony by way of opposition thereto, if offered, and only after a finding of fact by the Commission that prohibited or unlawful acts have been threatened and will be committed and will be continued unless restrained, but no injunction or temporary restraining order shall be issued on account of any threat, prohibited or unlawful act except against the person or persons, association or organization making the threat or committing the prohibited or unlawful act, or actually authorizing or ratifying the same after actual knowledge thereof. That substantial and irreparable injury to petitioner's property will follow, that as to each item of relief to be granted, greater injury will be inflicted upon the petitioner, be the denial of a relief than will be inflicted upon respondents by the granting of relief, that petitioner has no adequate remedy at law, and that the public officers charged with the duty to protect petitioner's property are unable or unwilling to furnish adequate protection. In HSBC, Employees Union versus NLRC, petitioner union in opposing the NLRC's grant of the injunctive relief to the Hong Kong and Shanghai Banking Corporation Limited, respondent bank, vigorously maintains that the petition for injunction filed by respondent bank with the NLRC suffers from a fatal flaw, for it failed to specifically allege therein the matters set forth under numbers 3 and 4 of Article 225 of the Labor Code. The Supreme Court, however, ruled that it is not necessary for the party applying for temporary restraining order and or a writ of preliminary injunction to allege verbatim the requisites for the issuance of the temporary restraining order and or writ of preliminary injunction under Article 225. It suffices that there are sufficient allegations that members of petitioner union were unlawfully preventing or obstructing the free ingress to egress from the private respondent bank's premises and disrupting its operations, causing great and continuing damage thereto in terms of lost revenues. These allegations, as found by public respondent NLRC, were proven by private respondent bank during the proceedings for the issuance of the writ of preliminary injunction. hearing notice thereof. Hearing shall be held after due and personal notice thereof has been served, in such manner as the Commission shall direct, to all known persons against whom relief is sought, and also to the Chief Executive and other officials, or the province or city within which the unlawful acts have been threatened or committed, charged with the duty to protect by petitioner's property. Reception of evidence. The reception of evidence for the application of a writ of injunction may be delegated by the Commission to any of its labor arbiters who shall conduct such hearings in such places as he or she may determine to be accessible to the parties and their witnesses, and shall thereafter submit his or her report and recommendation to the Commission within 15 days from such delegation. Ocular inspection in injunction petitions. The Chairman and Commissioner, Labor Arbiter, or their duly authorized representatives may at any time during working hours conduct an ocular inspection on any establishment, building, ship or vessel, place or premises, including any work, material, implement, machinery, appliance, or any object therein, and ask any employee, laborer, or any person, as the case may be, for any information or data concerning any matter or question relative to the object of the petition. Ocular inspection reports shall be submitted to the appropriate division within 24 hours from the conductor. Cases over which Commission may issue injunction. The Commission has the power to issue injunction in the following cases: ordinary labor disputes, picketing, strike, or lockout. Strike or lockout. Injunction in ordinary labor disputes. A preliminary injunction or restraining order may be granted by the Commission through its division pursuant to the provisions of paragraph E of Article 225. Labor dispute. Injunction in ordinary labor disputes. Injunction in ordinary labor disputes. A preliminary injunction or a restraining order may be granted by the Commission through its divisions pursuant to the provisions of paragraph E of Article 225 when it is established on the basis of the sworn allegations in the petition that the acts complained of involving or arising from any labor dispute for the commission which, if not restrained or performed forthwith, may cause grave or irreparable damage to any party or render ineffectual any decision in favor of such party. A certification of non-forum shopping shall accompany the petition for injunction. The writ of preliminary injunction or temporary restraining order shall become effective only upon posting of the required cash bond in the amount to be determined by the commission to answer for any damage that may be suffered by the party joined. If it is finally determined that the petitioner is not entitled thereto. Injunction and picketing. It is well settled that no injunction may be issued against the conduct of picketing by the workers, it being part of the freedom of speech guaranteed by the Commission. Only in the following cases may injunction be issued in case of picketing. If the picketing is carried out through its use of illegal means, if violence and other illegal acts are employed, if injunction is necessary to protect the rights of the third parties. Under any of the circumstances mentioned above, the injunction should be enforced only to the extent necessary to correct the violations of law, but should not prevent the workers from exercising the right of peaceful picketing. Injunction in strike or lockout. Injunction in strikes and lockouts generally prohibited exception. As a general rule, strikes and lockouts validly declared enjoy the protection of law and cannot be enjoined unless illegal acts are committed in the course of such strikes or lockouts. Ordinarily, the law vests in the NRRC the authority to issue injunctions to restrain the commission of illegal acts during strikes and pickets. This general prohibition holds true although it may appear to be illegal in character because a strike is treated as a weapon that the law guarantees to employees for the advancement of their interest and for their protection. B. An injunction may be issued against the holding of the strike itself. However, the Supreme Court has ruled in the following cases that the strike itself may be enjoined. San Miguel Corporation versus NLRC, where the strike was based on non-strikable grounds, that is for failing to exhaust all the steps of the grievance machinery. And arbitration proceedings provided in the CBA. Ilo at Buklod ng Magagawa versus NLRC, where the strike was held in violation of the law, RA number 6727, which prohibits the conduct of strike grounded on wage distortion. Bulletin Publishing versus Sanchez, where the strike was held to compel the employer to ignore the law. And San Miguel Corporation versus NLRC, where the strike was staged after the notice of strike had been converted into a preventive mediation case. Temporary restraining order, TRO. Issuance of a TRO requisites if the petitioner shall also allege that unless a TRO shall be issued without notice, a substantial and irreparable injury to petitioner's property will be unavoidable. Such a TRO may be issued upon testimony under oath or by affidavits of the petitioner's witnesses, sufficient if sustained to justify the commission of the issuance thereof. Issuance of ex parte TRO. The issuance of an ex parte TRO in a labor dispute is not per se prohibited. Its issuance, however, should be characterized by care and caution for the law, because that it be clearly justified by considerations of extreme necessity. Example, when the commission of unlawful acts is causing substantial and irreparable injury to company properties and the company is for the moment bereft of an adequate remedy at law. This is as it ought to be, for imprudently issued TROs can break the back of employees engaged in a legal strike. Oftentimes, they unduly tilt the balance of a labor warfare in favor of capital. When that happens, the deleterious effects of a wrongfully issued ex parte TRO on the rights of striking employees can no longer be repaired by for they defy simple monetization. Moreover, experience shows that ex parte applications for restraining orders are often based on fabricated facts and concealed truths. A more becoming sense of fairness, therefore, demands that such ex parte applications should be more minutely examined by hearing officers, lest that such ex parte applications should be more minutely, lest our constitutional policy of protecting labor becomes nothing but a synthetic shibboleth. The immediate need to hear and resolve these ex parte applications does not provide any excuse to lower our vigilance in protecting labor against the issuance of indiscriminate injunctions. This equalizing stance was not taken by the NRC when, in bisig ng mga manggagawa versus Concrete Aggregates Inc., FSM versus NLRC, it conducted an ex parte hearing and issued an ex parte TRO and sent the notices of hearing and the ex parte TRO to the wrong address of the petitioner union, an act suspected by the union to have been done deliberately by a private respondent company, Concrete Aggregates Corporation, in order for the union not to be able to immediately post the petition praying for a TRO, and so herein private respondent company would be scot-free when it presented its ex parte evidence. Consequently, it was held here that the petitioner union was denied the right to attend the hearing held on April 13, 1992, while the private respondent company enjoyed a field day presenting its evidence ex parte on the basis of uncontested evidence. Public respondent NLRC on the same day, April 13, 1992, temporarily enjoined petitioner union from committing certain alleged illegal acts. Again, a copy of the order was sent to the wrong address of petitioner union. Knowledge of the order came to petitioner union only when its striking members read it after it was posted at the struck areas of the private respondent company. Effectivity of a TRO. A TRO is effective for no longer than 20 days, reckoned from the posting of the cash bond required under the NLRC rules. During this period, the parties shall be required to present evidence to substantiate their respective positions. In the main petition, this 20-day limit rule is in keeping with the rationale that a TRO cannot exist indefinitely, for it is truly temporary. Cash bond. No TRO or writ of preliminary injunction shall be issued except on the condition that petitioner shall first file an undertaking to answer for the damages and post a cash bond in the amount of 50,000 pesos or such higher amount as may be determined by the Commission to recompense those enjoined for any loss, expense, or damage caused by the improvident or erroneous issuance of such order or injunction, including reasonable costs, together with a reasonable attorney's fee and expense of defense against the order or against the granting of any injunctive relief sought in the same proceeding and subsequently denied by the Commission. Release of TRO, writ of preliminary injunction requiring the posting of bond. NRC Administrative Order Number 12-04, Series of 2012 prescribes that in the event that a TRO, preliminary injunction, is granted and the posting of a bond is required, or presiding commissioners are directed to sue the release of such order. The resolution through the executive deputy, executive clerk of court, or of their respective divisions. Accordingly, the ECDECs are enjoined to issue notice directing the petitioner to post the required bond. Non-compliance with injunction order. The order or resolution enjoining the performance of illegal acts shall be immediately executory in accordance with the terms thereof. In case of non-compliance, the Commission shall impose such sanctions and shall issue such orders as may be necessary to implement the said order or resolution, including the enlistment of law enforcement agencies having jurisdiction over the area for the purpose of enforcing the same. Prohibition of issuance of injunction in certain cases. Administrative investigation by employer of its errant employees cannot be restrained or enjoined. Injunction will not lie to restrain an employer from conducting an administrative investigation of an erring employee. Administrative investigation of an errant employee is the sole and exclusive prerogative of the employer. Such investigation cannot be thwarted or nullified by arguing that the employer is the accuser, prosecutor, and judge at the same time. Dismissal of employees cannot be enjoined. In Philippine Airlines IAC versus NLRC, it was declared that the dismissal of employees affected by the employer cannot be enjoined by way of a petition for injunction filed by the affected employees with the NLRC. It is clear that the jurisdiction of the NLRC in illegal dismissal cases is confined only to appeals from the decisions of labor arbiters in illegal dismissal cases under Article 224. It cannot therefore entertain a petition for injunction filed by employees which challenges the dismissal orders of the employer. Article 225 does not provide blanket authority to the NLRC or any of its divisions to issue writs of injunction, considering that the rules of procedure of the NLRC make injunction only an ancillary remedy in ordinary labor disputes. Under the Labor Code, the ordinary and proper recourse of illegally dismissed employees is to file a complaint for illegal dismissal with the labor arbiter, where the employees disregarded this rule and directly went to the NLRC through a petition for injunction, praying that the employer be enjoined from enforcing its dismissal orders. The NLRC has exceeded its jurisdiction when it issued the writ of injunction granting the employee's petition for injunction and ordering the employer to reinstate them. Injunction cannot be issued by NLRC in a separate injunction proceeding to reinstate employees pending their appeal to the NLRC. In Silahis International Hotel INC versus NLRC, Petitioner Hotel, upon learning of the labor arbiter's decision declaring private respondents as having lost their employment status for staging an illegal strike, and without waiting until said decision became finally executory, barred them from entering the hotel and terminated their services. Respondents filed their appeal to the NLRC within a 10-day reglementary period, and thereafter they filed a very urgent petition for the issuance of preliminary mandatory injunction under Article 225 of the Labor Code, not in the illegal strike case then on appeal but in separate proceeding. In that petition, respondents, petitioners herein alleged that petitioner Silahis Hotel terminated the employment and respondents even before the labor arbiter's illegal strike decision became finally executory, and that most of the employees terminated were not union officers nor proved to be participants in the strike. They further aver that the termination of respondents' employment would cause grave or irreparable injury, which can be corrected by the writ of preliminary mandatory injunction. Subsequently, the First Division of the NLRC issued in a minute resolution an order in favor of respondents ordering petitioner Silahis Hotel to reinstate either physically or in payroll at respondents' option the hearing of private respondents. The Supreme Court declared that what the private respondent did constitutes forum shopping. By filing another petition involving the same essential facts and circumstances in the same age as in this case, where respondents filed their appeal and injunction case separately, and the NLRC respondents approached two different fora in order to increase their chances of obtaining a favorable decision of action. This practice cannot be tolerated and should be condemned. Further, it was declared that public respondent NLRC erred when it entertained the separate injunction case filed by respondents. It should have consolidated the petition for injunction with the illegal strike case already on appeal, for the fact of appeal and the attendant circumstances were stated in the petition and even acknowledged in the question resolution of the NLRC. Number 11. Resort to ordinary remedy in law and equity. Nothing in the law or in the rules shall deprive any party of claiming the cause of action under or upon such undertaking from electing to pursue his or her ordinary remedy by suit or in equity. Roman numeral number 8 under 225. Article 225. Power to grant extraordinary remedies. New remedy provided under the 2011 NLRC Rules of Procedure, although not proved provided under Article 225 of the Labor Code nor in any other provisions thereof. The 2011 NLRC Rules of Procedure introduced this new legal concept of extraordinary remedies. Extraordinary remedies. Other provisions introduce this new legal concept of extraordinary remedies. In Rule number 12, since this is a freshly minted remedy, there has yet been no case law thereon. What is clear though is that this remedy is not equivalent to nor a substitute for appeal. It is directed against orders or resolutions issued by labor arbiters in the course of the proceedings before him, including those issued during the execution stage thereof. Grounds: the petition for extraordinary remedy may be entertained only if there is no appeal or any other plain, speedy, and adequate remedy in the ordinary course of law, and based on any of the following grounds. If there is prima facie evidence of abuse of discretion on the part of the labor arbiter, if serious errors in the findings of facts are raised, which, if not corrected, would cause grave or irreparable damage or injury to the petitioner. If a party by fraud, accident, mistake, or excusable negligence has been prevented from taking an appeal, if made purely on questions of law, or if the order or resolution will cause injustice if not rectified. Initiation to verified petition. The party aggrieved by any order or resolution of the labor arbiter, including those issued during execution proceedings, may file a verified petition to annul or modify such order or resolution. The petition may be accompanied by an application for the issuance of a temporary restraining order and or writ of preliminary or permanent injunction to enjoin the labor arbiter or any person acting under his or her authority to desist from enforcing said resolution or order. Exceptional nature of petition. The uniqueness of this remedy is underscored by the fact that the initiation and filing of this petition constitutes the exception to the rule that no appeal from the order or resolution issued by the labor arbiter during the execution proceedings or in relation to incidents other than a decision or disposition of the case on the merits should be allowed or acted upon by the Commission. Petition covers any order or resolution of labor arbiter. It is important to stress that this extraordinary remedy may be availed of not only in relation to the orders or resolutions issued by the labor arbiter during the execution stage of the proceedings, but to all of his orders or resolutions on any other issues during the pendency of the case before him. It is thus not solely confined to the execution stage, but to all other aspects of the entire labor arbiter's proceedings where he issues any order or resolution. An example is when a labor arbiter denies an employer's motion to dismiss an illegal dismissal case grounded on lack of jurisdiction because the complainant is not an employee but a corporate officer. Under this situation, the employer can avail of this extraordinary remedy against such order of denial while the proceeding before the labor arbiter is ongoing, and without waiting for the case to be decided by him. When and where to file. No later than 10 days from receiving the order or resolution of the labor arbiter, the aggrieved party may file a petition with the Commission, furnishing a copy thereof to the adverse party. Requisites for validity of petition. The petition for extraordinary remedy shall be accompanied by a clear original certificate to a copy with the order or resolution sealed together with clear copies of the document related, relevant or related to the said order or resolution for the proper understanding of the issues involved. Contain the arbitral docket number and appeal docket number if any. The state, the material date showing the timeliness of the petition be verified by the petitioner himself or herself in accordance with Section 4, Rule 7, the Rules of Court as amended, in the form of a memorandum which shall state the ground relied upon, arguments in support thereof, and the leaves prayed for being 3 legible written or printed copies and accompanied by certificate of non-forum shall be proof of service upon the other party of parties, the labor arbiter who issued the order or resolution being assailed or questioned and proof of payment of the required fees. Both labor arbiter and party must be impeded in the petition. Both the labor arbiter and the adverse party must be impeded as a public and private respondents respectively. This means that the labor arbiter must be jointly impeded with the private respondent as nominal capacity. Private respondent refers to the party interested in sustaining the order or resolution of the labor arbiter. It shall be the duty of the private respondent to appear and defend both in his or her behalf and that of the public respondent, and the cost awarded in such proceedings in favor of the petitioner shall be against the private respondent only. The public respondent shall not appear or file an answer or comment to the petition or any pleading therein. Service and filing of pleadings. The party filing the pleadings should serve the other party with copies thereof in accordance with Rule 13 of the Rules of Court, furnishing the labor arbiter with a copy thereof. If the last day to serve and file a pleading falls on a Saturday, Sunday, or holiday, the pleading should be served and filed on the first working day immediately following such Saturday, Sunday, or holiday. Answer to petition. Within 10 calendar days from receipt of the petition, the private respondent should file his or her answer, therein stating the ground or grounds why the petition should be denied. Failure on the part of the private respondent to file his or her answer within the said period may be construed as a waiver to file the same. Opposition to injunctive relief prayed for in petition. In case the petitioner also prays for injunctive relief, the private respondent may file his or her verified opposition or comment to the application for injunctive relief not later than 5 calendar days from receipt of a copy of the petition. Effect of filing of petition. On the proceedings before the labor arbiter. Upon filing of the petition, the proceedings before the labor arbiter shall continue unless restrained by the NLRC. On execution, critical 15-day period. In case of execution, the proceedings shall not be suspended, but no money collected or credit garnished may be released of personal properties levied upon be sold by public auction within 15 calendar days from the filing of the petition. If no temporary restraining order or writ of preliminary injunction is issued the said period, the money collected or credit garnished should be released and or the properties levied upon by public auction from the proceeds of the sale applied to testify the judgment. The significance of this ordinary remedy is that the mere filing of a petition, the NRC cannot for a period of 15 days enforce the rate of execution, list the money that he has already collected or credit that he has already garnished, or sell by public auction the personal properties he has levied upon. And on the part of the bonding company and the banks concerned, they are not under legal compulsion to release the garnished amount to the employee within the said 15-day period. This period may become longer once the NRC issues a 20-day temporary restraining order or a 60-day writ of preliminary injunction, and it may be extended further beyond these periods in the event the NLRC makes the injunction final. Satisfaction of judgment. In case of execution proceedings, the labor arbiter should immediately inform in writing the commission or the division where the petition is pending of the satisfaction of the judgment, and if circumstances warrant, the commission should dismiss the petition for being moot. Disposition of records. The records of the case should not be elevated to the commission unless otherwise ordered, in which case the execution proceedings shall continue with the labor arbiter retaining copies of documents relevant and necessary for this purpose. Effect of filing of subsequent petition involving the same issues. In the event of filing of a subsequent petition involving the same issues, suspension of the release of money collected or credit garnished, or the suspension of auction sale over properties levied upon under the first paragraph shall not apply. 13. Issuance of ex parte TRO. If it shall appear from facts shown by the verified application and affidavits that great and irreparable injury, damage would result to the petitioner before the petition can be resolved, the Commission may issue a TRO ex parte effective for a non-extendable period of 20 calendar days from service of the private respondent. Issuance of writ of preliminary injunction. Upon the filing of a verified application for injunctive relief, together with supporting affidavits and documents, the Commission may issue a writ of preliminary injunction based on any of the applicable grounds provided for in Section 3, Rule 58 of the Rules of Court, for the preservation of the rights of the parties pending the resolution of the petition. The writ of preliminary injunction shall be effective for a non-extendable period of 60 calendar days from service of the private respondent. Issuance of TRO or writ of preliminary injunction effect. The issuance of a TRO or a writ of preliminary injunction, unless otherwise declared by the Commission, shall not suspend the proceedings before the labor arbiter or stay the implementation of the writ of execution, but shall only restrain or enjoin such particular act or acts as therein decreed to be restrained or enjoined. Posting of cash bond. Requirement to post cash bond. The issuance of a TRO or writ of preliminary injunction, the Commission shall require a posting of a cash bond in the amount of 50,000 pesos or such higher amount as may be determined by the Commission to recompense those enjoined for any loss, expense, or damage caused by the improvident or erroneous issuance of such order or injunction, including all reasonable costs. An additional cash bond may be required by the Commission in the issuance of a preliminary injunction. Clearly, the bond contemplated is only cash bond, not surety or property bond. Thus, the TRO or the writ of preliminary injunction will only become effective upon posting of a cash bond. Effectivity upon posting a cash bond. The TRO or writ of preliminary injunction shall become effective only upon posting of the required cash bond. No writ of preliminary injunction to TRO deemed vacated. In the event that the application for a writ of preliminary injunction is denied or not resolved within the said period, the TRO is deemed automatically vacated. Grounds for objection toward dissolution of TRO or writ of preliminary injunction. The application of a TRO or writ of preliminary injunction may be denied, or if granted, may be dissolved on any grounds provided for in Section 6, Rule 15 of the Rules of Court. Section 6. Grounds for the objection to and or for motion of dissolution of injunction or restraining order. D. Application for injunction of restraining order or restraining order may be denied upon the showing of its insufficiency. The injunction or restraining order may also be denied, or, if granted, may be dissolved on other grounds upon affidavits of the party or person enjoined, which may be opposed by the applicant also by the affidavits. It may further be denied, or if granted, may be dissolved if it appears after hearing that although the applicant is entitled to the injunction or restraining order, the issuance or continuance thereof, as the case may be, would cause irreparable damage to the party or person enjoined, while the applicant can be fully compensated for such damages as he may suffer. In the former, files a bond in an amount fixed by the court, condition that he will pay all damages which the applicant may suffer by the denial or the dissolution of the injunction or restraining order. If it appears that the extent of the preliminary injunction or restraining order granted is too great, it may be modified. Resolution or petition. Of petition. If the Commission finds that the allegations of the petition are true, it shall render judgment for the relief prayed or to which the petitioner is entitled, and or grant the final injunction perpetually enjoining the labor arbiter or any person acting under his or her authority from the commission of the acts or confirming the preliminary injunction. However, the Commission may dismiss the petition if it finds that the same is patently without merit, that it was prosecuted manifestly for delay, or that the questions raised therein are too substantial to require consideration of an appeal or any other plain remedy and adequate remedy in order the course of law is available. Recovery from injunction 1. The amount of damages that may be recovered by the private respondent from the injunction 1, the petitioner shall be asserted and awarded in the decision, order, resolution, finally disposing of the issue of application for injunction. So that is Article 225, the reading of Article 225. This is the power of the Commission. So next video will go to Article 226 and 227. Medyo mahaba-haba po ang 227. So see you guys in my next